Seek your Lordship's indulgence, Your Lordship. If I may be allowed to mention from the hearing matters, item 8 and 9. I have some personal difficulty today, Your Lordship. If these matters can come up next week or
Who's for the other side?
Yes, my lord.
Any
For
objection?
item number, no objection.
We'll have it after the vacation,
yes.
Yes.
as paid for by Mr. A.R. Malhotra, learned counsel for the appellant. List the matter again. No, before that, and not objected to by the other side. List the matter again after the ensuing puja vacation. Item 8, item 9.
I'm obliged.
Your Lordship, this item number 10 also, my lord. I have taken the consent of the other party also, my lord. This matter
Yes,
may be taken after. Yes,
What is the case about?
this is a criminal appeal, my lord. A conviction under section 3761 of IPC, my lord.
Okay.
A conviction for a period of 10 years, my lord.
You're for the appellant.
Appellant, my lord.
What is your difficulty?
I need some time for preparation, my lord. Just
Miss Linda?
No objection, madam.
Okay. Mr. Saurabh Pradhan, learned counsel for the appellant, submits that he needs some time to prepare the matter and therefore prays that the matter be posted again after the ensuing puja vacation. Stop. Miss Linda L. Fumble, learned public prosecutor, has no objection. Stop. Next para. In view of above, list the matter again after the puja vacation on a date to be fixed by the registry.
obliged.
Your Lordship, may I kindly make a mention on item 11? The leading counsel is on medical leave, and if the matter may be taken up on next Thursday,
Leading counsel is on
medical leave.
medical leave. Oh, Mr. Samuel.
Miss Valentina.
Sorry?
Miss Valentina,
Oh, Valentina.
His Lordship.
Is there any urgency in the matter?
No, Lordship.
Who's for the other side? Mr. Liantrima is there also? Have you informed the other side?
Yes, I have taken the consent on the other side.
This also after vacation. As paid for on behalf of Miss Valentina Laldinpui, who is said to be on medical leave. List the matter again after the ensuing puja vacation. Yes.
May seek your lordship indulgence in making in mentioning one unlisted item, my lord.
Yes. What matter is that?
Actually, my lord, the case was already listed yesterday, but due to mishap on the road, I was unable to arrive on time.
Which
So,
case?
My case, my lord. Justice Marley. It was listed at Justice Marley yesterday.
It was listed before court number 2.
Yes, my lord.
Then what happened?
I was unable to attend the court.
What was the order passed?
It was to be listed after vacation, but my lord, one attachment order was to be passed on 3rd of October, my lord. So if it may be posted again on Monday, this Monday, my lord.
Why don't you mention it before the same court? Since it was listed in that court.
But my lord, this is the senior judge, my lord.
Who's for the other side?
Mr. P.C. Lalthang Moya.
Okay.
I have already informed them, my lord. Also,
You want it today?
no, my lord, Monday.
On Monday?
Yes, my lord.
All right.
Orders, item number 7.
Lordship, regarding this item, I repeatedly prayed for time, Lordship. Even as instruction was received by me, my Lord, there is some difficulty in bringing up the responsible officer to subscribe the affidavit. Inasmuch as the responsibility of taking up the cases in Aizol of NCB cases have now recently been shifted from Guwahati to Agartala unit. So in that case, my lord, if your lordship kindly can accept my verbal submission, I mean, without any written objection, that I'm ready, my lord.
All right. You ready? Yes, Mr.
My lord,
Counsel.
I'll not argue this matter on merit. I'll just take a few points with regard to long incarceration and the prolonged trial, my lord. I'll just take only that point.
See, you have to at least tell us the basic facts.
I'll come to the facts. So that is
Then that's how you start your argument.
that is correct, but I'll just mention that. I'll not argue on merit. My lord, this is a case of seizure of 2.553 kg of heroin.
2.553.
3 kg of heroin. It was seized from a vehicle driven by the present applicant. The registration of the vehicle is AS11 DC 5863. Now, while coming from Champhai to Aizawl, the vehicle was halted at Seling, and the place of seizure is at Seling. The case was registered in pursuance of the information received by SI Nalchuan Moya CID Special Branch. Your Lordship will see at page 28. That is the information received by SI Nalchuan Moya. Now, before I read this, my lord, there are 9 witnesses listed in this case, and out of the 9 witnesses, only 2 prosecution witnesses have been examined till date. Now, coming to page 28, there is the information report recorded by SI Nalchuan Moya.
Total 9 witnesses.
Total 9 witnesses. Out of the 9 witnesses, only 2 have been examined. And this Nalchuan Moy is the person who was already examined.
Who is he?
He is
the informant.
Informant and the seizing officer, my lord.
And he's arrayed as PW.
PW number 3.
Then who is the other witness?
The other witness is the Deputy Superintendent of Police, CID, Larin Puyachen.
He's PW.
PW, wait, my lord. PW number 1.
So 1 and 3 have been examined.
1 and 3 have been examined.
7 remaining.
Yes, my lord.
When was the arrest?
2/5/2023.
Arrest and seizure.
Yes, my lord. Now, my lord, I'll just read this information report first.
Yes.
On 2/5/2023, I have received specific information that some unknown persons were strongly suspected of possessing and transporting suspected heroin from Champhai site to Seling Aizawl district. In this regard, I reduced the information report in writing and immediately submitted to Deputy SP, CID Special Branch, Mizoram Aizawl. So self with party left office and proceed to Seling to intercept the suspected vehicle at Seling Aizawl district and to conduct search, recovers, seizure and arrest. And the report of seizure and arrest is at page 29. May I read, my lord?
Yes.
As per provision of section 57 of the NDNPS Act, I am submitting herewith my report regarding the seizure and arrest as under. On 2/5/2023 at 5:40 p.m., I had seized 2.553 kg of suspected heroin 200 numbers of plastic soap cases at Seling Aizol Road, Aizol District, Mizoram, from the possession of Abdul Majid Laskar, son of Robijul Ali Laskar Village, Kuli Chara, District, Kachar, Assam. The possessor was arrested by preparing proper arrest memo after informing her grounds of her arrest. It has to be he.
His arrest.
His. Intimation of his arrest was also communicated to his brother Abdul Hakim Laskar. Now, this information report was submitted by S.I. Lalchun Moya to the officer in charge, Special Narcotic Police Station, CID Crime. Now, the property search and seizure form is at page 30, Madam. The property, the illicit article was seized at 2/5/2023 at 5:40 p.m. And the place from where it was seized is at Seling Village, Aizol Road. The illicit article was recovered from the vehicle driven by the applicant herein, Madam. May I take your lordship to the first information report submitted by S.I. Lalchulmoy. It is on page 34 and 34A.
Yes.
I'll read this one. On 2/5/2023 at 5 a.m., information was received from reliable sources stating that some unknown persons were strongly suspected of transporting contraband drugs from Champhai to Aizol, Mizoram by committing an offense in contravention of the provisions of the ND&PS Act 1985. In this regard, written information report was submitted immediately to the Deputy SP CID SB, as search warrant could not be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, and self with party immediately left CID Special Branch Office for Seling, Aizol District, Mizoram, to conduct search, seizure, and arrest of the suspected persons as per provision of under Section 42 ND&PS Act 1985. On reaching Seling, Aizol District, Mizoram, arrangement of two reliable independent witnesses were made, namely Raymond Lalding Liana, son of so-and-so, and Lomsang Zola, son of so-and-so, Aizol District, Mizoram. Self with party intercepted one truck Ashok Leyland bearing registration number AS11 DC 5863, which was coming from Champhai towards Aizol at Seling, Aizol Road, Aizol District, Mizoram. I introduced myself to the suspected person by telling my name and that I am a police officer working at CID Special Branch. The suspected person and the driver of the said vehicle introduced himself as Abdul Majid Laskar, son of so-and-so, District, Kachar, Assam. I told him that he was suspected of possessing contraband drugs and asked him to take out all his hidden articles, if any. Accordingly, Abdul Majid Laskar so-and-so took out 200 numbers of plastic soap cases concealed inside black polythene. 18 numbers of black polythene contains 11 numbers of plastic soap cases each, and 1 number of black polythene contains 2 soap cases from inside driver cabin, and handed over to us. On opening 200 numbers of plastic soap cases, powder packed in transparent polythene suspected to be heroin were found. Weight of the suspected heroin was taken and totally weighs 2.553 kg, value of rupees 50 lakhs in local market rate. The suspected heroin was marked as A12 so-and-so and for identification. At page 34A. So the suspected heroin was seized from the possession of Abdul Majid Laskar so-and-so, Assam, on 2/5/2023 at 5:40 p.m. Weighing, packing and sealing of the seized suspected heroin was done in the presence of the possessor and the 2 civilian witnesses. I also seized the conveyance vehicle truck bearing so-and-so AS11 DC 5863 along with documents and ignition and 1 mobile phone. The suspected person was arrested in presence of witnesses after informing his grounds of arrest. Intimation of the arrest of Abdul Majid Laskar, son of Robijul Ali Laskar of Kulichara Village, PO Jamalpur, so-and-so District, Kachar, Assam, was given to his brother Abdul Hakim Laskar. I therefore pray that a case under appropriate section of law may kindly be registered against Abdul Majid Laskar, Assam, for violating the provisions of ND&PS Act 1985. Thereafter, charge sheet was submitted against the applicant herein, and 1 co-accused. The charge sheet can be seen at page 34. B to 41. Your Lordship may come to page 36.
Yes.
These are the charge sheet. My Lord, I'll read from this beginning. Or the allegations against the present applicant. Here it is mentioned in,
This is in the form of a petition.
yes, my Lord. The evidence against the accused applicant here is at page 38B, para 23.
Yes.
These are the evidence against the accused person Abdul Majid Laskar, alleged by the NCB. Para 23. Sub,
When was it handed over to the what do you call that? NCB.
NCB.
Because
It was
the
taken over by NCB on 4/5/2023. Everything was done by the Special Narcotic Police.
it was taken over from the
Special Narcotic.
special narcotic. What do you call that?
One Special Narcotic Police. They called CID Special Branch. CID Special Branch. They were called CID SB. And the case was registered under the Special Narcotic Police case number 30 of 2023. The role of the NCB is to submit the charge sheet, man. The seizure,
Investigation was done by the
special,
CID.
special, yes, man.
CID SB.
CID, yes.
Then after that, it was handed over to the
NCB,
NCB on 4/5.
4/5/2022.
And when did they file the charge sheet?
25/1/2024. They have also collected evidence, Malo. Like they have collected a CDR record of the applicants and the co-accused.
CDR.
Yes, Malo.
So FIR is dated 2/5/23. Then investigation done by the CID SB.
Malo.
Matter was taken over by the NCB on 4/5/23. However, they also did some investigation
Malo.
collecting the CDR.
Yes.
And
the
charge
bank-
sheet
and
filed
bank
on
account.
25/1/24.
The allegation against me was mentioned in para 23.
Yes, please read.
The seized 2.553 kg of heroin was recovered and seized from the possession of accused Abdul Majid Laskar when he was in the process of trafficking it to Assam. So he is the trafficker and transporter of the seized 2.553 kg heroin. Accused Abdul Majid Laskar has disclosed in his statement that he was consciously involved in the trafficking of 2.553 kg heroin. Accused Abdul Majid Laskar has also disclosed the names and mobile numbers of other conspirators in his statement, which were further corroborated during the investigation. Accused Abdul Majid Laskar was the driver of the truck which was used in the trafficking of 2.553 kg ganja. From the CAF of mobile number so-and-so of accused Abdul Majid Laskar, it is found that both the mobile numbers are registered in his own name. Page 39.
CAF means?
CAF means, Manot, I don't know what's the full form of CAF.
Okay. He has got two SIM cards.
Yes, man.
Yes.
Page 39. From the analysis of CDR of mobile numbers so of accused Abdul Majid Laskar, it is found that accused Majid Laskar was in contact with the supplier of the drug James and also with the receiver of the drug Parul Hussein Ahmed. From the analysis of the bank account of the accused Abdul Majid Laskar, it was found that rupees 8,000 was transferred to the account of accused Majid Laskar by receiver of the drug Parul Hussein Ahmed. A report from FSL Mizoram has been received which confirmed the presence of heroin in all the samples.
So these people were also arrested? James and Paul?
No, James has not been arrested till date. Parul Hussein now is in custody. He had applied for anticipatory bail before this court. Now that anticipatory bail was rejected. Now he is in custody.
He's in custody.
Yes.
He is the one who supplied 8,000 rupees
It's the allegation.
through the bank.
So that
So-
was the allegation.
So the applicant was the sole occupant of that vehicle.
Yes, my
He
lord.
was the driver and nobody else
Nobody else.
in the vehicle.
So this one person, James, allegedly approached him.
It was an empty truck.
Yes.
Empty truck?
Yes. It's coming from Champai to Aizol.
I know.
Yes.
It was an empty truck.
That was not known. That wasn't known.
No backload, nothing like that.
No.
Okay. Then
So he was apparently he was approached by this Mr. James to transport this article to this Parul Hussein. Now the statement of the applicant recorded by Lal Romoya is at page 44, my lord.
yes, 44.
44 is the statement recorded by SI Lal Romoya Khiengte, Special Narcotic PS. I'll read this, my lord. On 27/5/2023, I traveled to Champai, Mizoram from Silchar, Assam by truck Asok Leyland, bearing registration number AS11DC5863 to deliver hardware goods. I reached Champai on 29/5/2023, and after I delivered all the goods, while I was parking the truck on the roadside at Champai, Chungte, one male person who named himself as James came to the vehicle and asked whether I can deliver heroin or not and promised me a sum of rupees 15,000. I agreed as I urgently need money as I need to undergo surgery to remove a kidney stone, and I hid the heroin inside the driver cabin cab. While I was having lunch at Kifang, a person who called himself as Parul called me through telephone and told me where to deliver the heroin. On 2/5/2023, when I reached Seling Aizol Road, Aizol District, Mizoram, I was intercepted on the road by police and two civilian witnesses. The police introduced himself to me by telling me his name and that he is a police officer working at CID, and I also introduced myself to the police officer. He told me that I was suspected of possessing contraband drugs and asked me to take out all his hidden articles, if any. Accordingly, I took out 200 number of plastic soap cases concealed inside black polythene. 18 numbers of black polythene contains 11 numbers of plastic soap cases, and 1 number of black polythene contains 2 soap cases from inside driver cabin, and handed over them to the police. Weight of the heroin was taken and totally weighs 2.553 kgs. The police formally seized the heroin in my presence and in the presence of two civilian witnesses on 2/5/2023 at 5:40 p.m. I was also arrested by the police after I was informed my ground of arrest, and intimation of my arrest was informed to my brother Abdul Hakim Laskar.
Mr. Fagzwala, see, this 18 numbers of black polythene
Yes.
contains 11 numbers of plastic soap cases. How can that be? Shouldn't it be the other way around? 18 numbers of individual polythene bags,
Mala.
how will they contain 11 numbers of soap cases? Soap case cannot be divided.
It appears that there are 18 numbers of polythene, and the total soap
So-
cases is 200.
So 11 polythene contains the soap case
Yes, Mala.
and the remaining 7 polythene is empty. Or what?
There is 1 number of black polythene which contains 2 soap cases.
Huh?
1 number of black polythene contains 2 soap cases.
No, that's different.
Yeah.
Before that, it says 18 polythene.
Yes.
18 black polythene contains 11 numbers of plastic soap case. Anyway,
my lord. So, as per the allegation, 200 number of plastic soap cases was recovered.
200 numbers of plastic soap cases.
Yes. Now that's
So how do you work out the math here? 11 plus 2 is 13. 13 soap cases, 18 black polythenes. Yet they say it's 200 numbers of 200 numbers of plastic soap cases.
yes.
Where's the Caesar memo? Caesar.
Your lordship will see the page 30. 30 to 33. And the report of the Caesar is at page 29. Here they say 200 numbers of plastic soap cases. And in the FIR, they also says 200.
So the property and search and seizure form does not mention individual soap cases.
No.
Serial number 9 says 2.553 kgs of suspected heroin. FSL is available here in your application.
It's not available, I think. No.
You have not enclosed
I
the
have not
FSL.
enclosed. I have not enclosed.
You have the FSL, Mr. Zoram Sana.
Yes, Your Lordship.
You have the FSL.
Official, I think I have seen it somewhere, but I might be mistaken.
Not here.
But as far as I know, Your Lordship, before the trial court, it's positive result, saying that they are containing heroin. My lord.
No, that we have already seen, whether it's positive or not. I'm asking you about whether the FSL report is in your hands or not.
I think it's not enclosed here with my lord.
That we know. Do you have a separate bunch of papers with you?
Right now, no, my lord. Sorry.
Then what kind of objection are you filing? You were intending to file?
I'm the objection which I received, Your Lordship, from the authority, saying that, my lord, actually the positivity, my lord, I think there is no issue there.
I'm not on positivity. You know very well. What I was saying is that the Caesar was 200 soap cases. But the FIR says only 12 soap case. Then again it says one soap case.
No, my lord, it's like this, my lord.
My lord, may I please-
Actually, 18 polythene bags, Your Lordship. 18 polythene black polythene bags containing 11 soap cases each, Your Lordship.
Each.
Each, yes, Your Lordship. It
Where do
says
you find that each?
It's on page 42, Your Lordship. The one that you have just recently looked at, Your Lordship. If I may take, Lordship, I'll read, my lord. It says,
Correct.
and there is still
Okay.
another one, another polythene, which contains only 2 soap cases. Altogether, they add up to 200.
All right,
soap
simple thing. We missed out this each. That's all.
each.
But the Caesar memo does not specify
Mali.
how many soap cases have been seized, which contains this much.
Caesar memo, my lord, I think also is not enclosed.
Caesar memo just says that 2.553 kilo. This is the
Official report, which is not a part of my application, my lord.
Okay, fine. Things are a bit clear because once when you say that 200 soap cases, and again in one place you say 18
Yes,
polythene bags containing 11 soap cases.
that was stated
But if
by-
it's each, that
Yes,
means you have to
Madam.
multiply that by 18.
Correct.
It's okay. Then
One of the statement was of the applicant was also recorded by the NCB. Before that, my lord, may I place the position of Nalchuan Moya, which was recorded in the court.
Lal Chuanmoya is PW.
Number 3. He is the seizing officer.
And what is the name of the other person? PW1?
Lalrin Puya Chenkul.
Dalrin Puya.
Lalrin Puya Chenkul. He is the person to whom the information was conveyed by Nalchuan Moya.
PW3 is the informant
Yes.
and seizing officer.
Yes, my lord.
And PW1 is?
PW number 1 is the report to whom he was given. The Lalchuan Moya gave the report to PW number 1.
I see. What is he? He was DSP CID.
Yes, Deputy SP, CID. His deposition is here, my lord. May I read his deposition, my lord? PW number 1.
No, before that, you say that he reported to him.
Yes. The report of Caesar was
Is there any document here
20,
by which that report was given?
I think it's page 29.
He reported in writing.
Yes.
Okay.
To the officer in charge, Special Narcotic Police Station, my lord.
So he was the officer in charge.
The signature here is, I think, is a different person. Inspector Arvan Alzoma. Your Lordship will see at page 34A. The signature which appears in page 29 and page 34A is similar.
Officer in charge.
Yes, my lord.
So, how did he report to the PW1?
Here, your Lordship may see the deposition of PW number 1, which I have just placed before your Lordship.
There's no document otherwise
There's no document.
that
Let me see.
PW3 reported to PW1 in writing.
Your Lordship will see at page 28 the information report is there. At the,
This
at
is
the
the
left
one.
side, here there's an acknowledgement by the Deputy Superintendent of Police.
So this is relevant, 28.
Now the report under section 57 was acknowledged by Officer in Charge Special Narcotic Police Station, but not the Deputy Superintendent of Police. The information report was recorded by SI Lalchuan Moya, which was received by Lorin Puya Sino. Lorin Puya Chenko, sorry. It was only with respect to the information report, not with regard to the report of seizure and arrest.
You may read this if you want.
The deposition of PW number 1 Lorin Puya Chenko, Deputy SPCID Special Branch. On 2/5/2023, I received information report submitted by SI Lalchuan Moya regarding his information received that some unknown persons were strongly suspected of possessing and transporting suspected heroin from Champai site to Seling. I appended my signature on the information report. Exhibit P1 is the information report and Exhibit P1 is the signature. Cross-examination by DL. It is a fact that the information was received by Lal Chuan Moya, Sub-Inspector CID SB. It is also a fact that I have received the information report from SI Lal Chuan Moya in the office of SSP CID Special Branch, but I do not know the exact time when I received the information report. It is a fact that the name of the accused persons, including the name of the vehicle and registration number, was not mentioned in the information report. It is a fact that I am involved in this case with regard to receiving of the information report only. It is not a fact that I am deposing falsely before the court today. Now, the evidence of Lal Chuan Moya, PW number 3. Has your lordship got it?
Yes.
I know accused Abdul Majid Laskar. On 23, I received information from source that strongly suspected of possessing and transporting heroin from Champai site to Seling. I reduced information into writing and submitted to DPSP CID Special Branch. After that, me and my party left to Seling to intercept the reported vehicle at Seling and to do necessary actions. At the roadsides of Seling, me and my party performed our duty and awaited the suspected vehicle. At around 5:30 p.m., the suspected vehicle, that is truck Ashok Leyland bearing registration number AS11DC5863, driven by accused Abdul Majid Laskar, arrived near our duty post and we intercepted it. Since we suspected him for transporting illicit drugs as per my information report, before taking any necessary actions, I called two persons, Raymond Lalding Liana and Lomsang Zola, both from Seling village, to witness our steps taken. After the two independent witnesses arrived and in presence of them, I asked the accused Abdul Majid Laskar to produce any contraband drugs if he possessed and transported. In the presence of witnesses, the accused Abdul Majid Laskar took out 18 big black polythene and one small black polythene from the driver's cabin cap. From each of the big black polythene, he took out 11 plastic soap cases each, and from the small black polythene, he took out the 2 plastic soap cases. Altogether, the plastic soap cases were 200 numbers. From each of the plastic soap cases, we recovered heroin packed in transparent polythene, and I seized the said heroin with its containers in presence of witnesses. Weighing of the seized heroin was taken at a PO, and altogether it was 2.553 kgs. Packing and sealing was done at the PO. I made a marking on each of the soap cases as A1 to NV for identification. I arrested accused Abdul Majid Laskar after informing his grounds of arrest, and intimation of his arrest was communicated to his brother Abdul Hakim Laskar. I also seized the involved truck with its documents and its ignition key and mobile phone from the possession of accused Abdul Majid Laskar. I then submitted my report of seizure and arrest and FIR to OC Special Narcotic PS and also handed the seized articles and accused Abdul Majid Laskar. Exhibit P1 information report. Exhibit P2 is seizure memo. Exhibit P3 is seizure index. Exhibit P4 is arrest memo. Exhibit P5 is report of seizure and arrest. Exhibit P6 and P6A are FIR, and P6A subclause A are signatures. Cross-examination by GL for accused Abdul Majid Laskar. It is a fact that I did not make the person who has given me information about the incident as one of the prosecution witness. It is a fact that I do not know whether some person has received information prior to the information being received by me. It is a fact that on the information report recorded by me, the name of the accused Abdul Majid Laskar or the particulars of the vehicle has not been mentioned. It is a fact that when I submitted the FIR to the OC Special Narcotics, I had mentioned about the seizure and arrest done by me. It is a fact that I cannot say whether the report of seizure and arrest was received by the OC on 2/5/2023 or 3/5/2023. It is a fact that I do not have a search warrant or authorization before I conducted the search. I do not agree that when we performed the search and seizure, the sun has already set. It is a fact that when the NCB did not record my statement in the instant case, it is a fact that my statement was apparently recorded by the Mizoram police officer. It is a fact that I effected the recovery from the driver cabin cap. It is also a fact that unless the black polythene is open, what was contained therein cannot be known. It is a fact that weighment of the seized article was done on the spot. However, sample was not drawn by me on that day. It is a fact that the black polythene, including all the soap cases, was open. I deny that while taking the weighman, the soap cases were included. It is a fact that I do not know whether I had made a marking on the soap cases or the transparent back of the alleged heroin. I deny that there were no civilian witnesses from selling at the time of weighman and at the time of seizure. It is a fact that immediately after the seizure, we have taken photograph of the seized article and the accused. It is a fact that I do not record the statement of accused Abdul Majid Laskar. It is a fact that there are no receipt or form indicating the deposit of seized article to the OC. It is a fact that there are no receipt or form indicating the deposit of seized article to the OC. Cross-examination by GL of accused Parul Hussein Ahmed. I do not know the accused Parul Hussein Ahmed and I do not seize anything from his possession. I do not know whether or not the accused Parul Hussein Ahmed is included in this case only from the sole statement of the accused Abdul Majid Laskar. It is a fact that the accused Parul Hussein Ahmed was not present while seizure of the seized article at selling and he was also not present inside the seized truck. It is correct that...
No, you can go. Go and type. I'll call you up. Yes, please
It
continue.
is correct that on being shown the inventory photograph today, no markings could be seen in the 200 transparent pack and the exact numbers of the soap cases cannot be ascertained. It is a fact that in the test memo enclosed in the charge sheet, page 18, section 2.4 used in the laboratory is left blank. It is also a fact that in the test memo there is no description of the seal used in order to compare that the exhibit received by the FSL bears the exact seal. I cannot say the exact color of the seized article which was seized by me. I also cannot say the exact color of the soap cases which contain the seized article seized by me. I do not know the involvement of accused Parul Hussein Ahmed in the instant case. My lord, the only thing which transpires from this evidence of the witnesses is that he had no receipt or form indicating the deposit of seized article to the OC, which is mandated under the narcotic seizure sampling rules. There is it's in the NDNPS seizure, storage, sampling, and disposal rules. Rule 5, ma'am. The rules which I have just referred is narcotic drugs and psychotropic substance, seizure, storage, sampling, and disposal rules, 2022.
Rule 5.
Yes, ma'am.
Yes.
Now here are all seized materials referred to in sub-rule 1 of rule 3, that is seizure of narcotic drugs and psychotropic substance. After seizure under the X shall be deposited by the seizing officer in the nearest godown designated under rule for within 48 hours from the time of seizure along with a forwarding memorandum in form 1. So this witness had accepted that there is no forwarding memorandum as mandated under the rules of the seizure sampling and disposal rules. Anyway, Manoj, that is on the merit, but I will not go further on merit. The statement of the applicant was also recorded. Then I left for Kaifang and reached there at about 2 p.m. I offloaded some of the goods loaded at Baba Loknath Transport at the shop of Rochung near Police Point at Kaifang. On the same day, I left Kaifang and reached Kozol at about 9 p.m. There I parked my truck near Police Gate and slept in my truck. During the daytime of 29/4/2023, I offloaded some of the goods loaded in my truck to different parties in Kozol Market and after that reached Champai at about 9 p.m. I parked my truck in the bypass after crossing about 2 kilometers from Police Check Gate, Champai, and I slept in my truck. It was Sunday on 30/4/2023 and the market was closed, hence the goods could not be offloaded from the truck. I went to the Champai market in the night of 30/4/2023 at about 9 p.m. On 1/5/2023, I offloaded all remaining items of my truck to 24 different parties in the Champai market area and then parked my truck at the downside of Champai market area, which is about 2 to 3 kilometers from the market area. Then I went to collect money from market as directed by Dilip Kumar. I collected 8,900 from JTS hardware stop at Champai market. After collecting the money, I returned to my truck. On 1/5/2023 at about 7 p.m., a person came to me and introduced himself as James. James told me to carry number 4, that is heroin, in my truck to Silchar, Assam. He offered 50,000 for this job and told that I will get the money from the party at Silchar after delivery of heroin to him. H also told me that he will hand over heroin to me at the downside area of the police gate, Champai. I went to the police gate, Champai, at about 9:30 p.m. I parked my truck there and rested in my truck. On 2/5/2023, I woke up at 5 a.m. in the morning and made an entry at police gate, Champai, at about 6 a.m. James called me after some time and told me to come to the downside area of police gate. I went about 3 to 4 kilometers towards the downside area from police gate and found James standing at the roadside. He gave signal to me and I stopped the truck. He handed over 2 black polythene packets of soap cases in which heroin was concealed. I concealed those packets in the cabin of my truck and then I left Champai for Silchar. I stopped my truck at about 1:30 p.m. just before the Kaifang market and cooked food. After having food, I left Kaifang and reached selling at about 5 p.m. There some people stopped my truck and introduced themselves as police officer of CID Special Branch Aizawl, Mizoram. They told me that they have information about trafficking of number 4 heroin in my truck. On their asking, I took out both black color polythene packets in which soap cases of heroin was concealed from the cabin of my truck bearing registration number AS11DC5863 and handed over to them. Police officer opened both packets and recovered 200 soap cases from the black color polythene packets. On weighing, the total weight of the heroin came to be 2.553 kg. The police officer seized the 2.553 kg heroin recovered from my truck and also my truck bearing registration number AS11DC5863. Thereafter, police officer arrested me and brought to the police station. This is my true and voluntary statement which I have stated truly and to the best of my knowledge without fear, force or inducement. I am giving answers to the questions asked by you to the best of my knowledge and I request you to type your questions and their answers as provided by me. Question number 1. For how long you are working as truck driver of Sundarlal son? Answer: for about 6 to 7 years. Question number 2. How much salary does Sundarlal son pay you for a month? Answer: Dilip Kumar, brother of Sundarlal son, pays me rupees 50,000 in a year. Sundarlal son is old and has returned to his village in Rajasthan. Once or twice in a year he comes to Silchar. All his business is being looked after by his brother Dilip Kumar. Question number 3. What is your mobile number? I have 2 mobile numbers, so and so. My mobile numbers are registered in my name. Question number 4. What is the mobile number of your wife? My wife's mobile number is so and so. Do you have any bank account? Question number 5. Answer: I have a bank account in the State Bank of India, Banka Bazar branch, Kachar, Assam. Question number 6. Does your wife...
Mr. Fazwala, why are you reading all these?
No, it's the statement that if your lordship...
What is your grounds for bail? We are hearing a bail hearing, not
See, my lord, as I have submitted earlier in before I started my argument, I'll just say that I'll not argue on merits. So this is only to apprise your lordship of the facts, which the statement recorded by the police and the NCB. So that is why I'm reading this, my lord. Now, my main point is that, see, this is a commercial quantity that is not doubted, my lord. So in a commercial quantity, my lord, section 37 of the Indian PS Act comes into play. My lord, the question of me having conscious or unconscious possession of the seized heroin which was recovered from the vehicle driven by me will come during the trial. I know that, my lord. That is section 35, that whether I have culpable mental state or not, my lord. That has to be proved by me. At this stage, my lord, why I am pressing bail for the applicant is that out of the 9 prosecution witnesses listed, till date, only 2 prosecution witnesses have been examined. Now, if I am not mistaken, according to my record, I have been in custody for about 513 days. As on 27/9/2024, as on today.
Yes.
Now, the manner in which the trial has been conducted, my lord, it is very unlikely that trial will be concluded within a period of 2 years or 3 years, my lord, as it stands like this. So my submission is that due to prolonged incarceration, my lord, section 37 is cannot come into play, my lord. There is a judgment of the Honorable Supreme Court, my lord, 2023, Life Law SC 533. Your Lordship will see at paragraph 4. I'll read this, my lord. As regard to the twin conditions contained in section 37 of the Indian PS Act, a learned counsel for the respondent state has been duly heard. Thus, the first condition stands complied with so far as the second condition, formation of opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty. The same may not be formed at this stage when he has already spent more than 3.5 years in custody. The prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such situation, the conditional liberty must override the statutory embargo created under Section 37, 1B, subclause 2 of the Indian PS Act. So that means Section 37 is not an absolute embargo when the petitioners have been incarcerated for such a long period, my lord. Another case, my lord, 2023 SCC Online SC 918, my lord.
Before you move on, that you were reading that statements and all that. At one point, I think you said that he was promised 15,000.
50,000.
How much was he promised?
50,000.
1.5.
50,000. 50.
That was before the NCB.
My lord.
But before the police, I think he said 15.
My lord, I have to relook that.
15, 1.5. I heard 15.
Maybe.
Of course, the last one which you read is 50.
Yes, my lord.
It's written 50. But what is that previous one you had said 15,000?
Let me see, my lord. Here is on page 44. The statement recorded by the Mizoram police at page 44, my lord. Yeah, here it says 15,000.
15.
Yes,
44.
15, page 44.
44. Yes, he said 15,000.
Yeah.
So this is what I noticed. Anyway, so what at one point he said 15,000 will be given. Was he paid any amount? He was given 8,000 in his bank.
The allegation against me that 50,000 was deposited in his bank account.
15 or 50?
That is,
I think it's 8,000.
well, yes, my lord. I'm not sure about that.
No, you read somewhere.
My lord.
At one point of time, 15,000 promised, before the NCB, 50,000, and in his bank, transferred by the person in Silchar, that was 8,000. That's how the second person was caught. Paul has not been traced, who was from Champai. Okay, coming back to your judgment, the facts here is that recovery of 247 kilograms of ganja, and the prolonged incarceration was 3.5 years,
Correct.
compared to your 513 days.
It's correct. But what I'm pointing out this judgment is that Section 37 is not an absolute embargo. Now another case, my lord. 2023 SCC online, SC 918. This is also a seizure of 92 cases, more than 92 cases of ganja. Your Lordship may come at page para 3. It appears that some of the occupants of the Honda City car, including Pravin Mauri and Punit Mauri, have since been released on regular bail. It is true that the quantity recovered from the petitioner is commercial in nature, and the provisions of Section 37 of the Act may ordinarily be attracted. However, in the absence of criminal antecedents and the fact that the petitioner is in custody for the last 2.5 years, we are satisfied that the conditions of Section 37 of the Act can be dispensed with at this stage, more so when the trial is yet to commence, though the charges have been framed. Here in this case, even though charges have been framed, trial has not commenced. Now in my case, trial has commenced, and out of the 9 prosecution witnesses listed, only 2 have been examined till date.
When is the next date? You are also defending the applicant in trial?
Yes, my lord. The next date is 1/10/2024 is for production of the accused only.
110?
2024.
But the prosecution witnesses have started, isn't it? Evidence.
It has started. 2
Then-
prosecution witnesses have been examined. And on 28/10, it was fixed for examination of witnesses. PW,
110 is for production only.
110 is for production only. So a separate date is used to be given in the trial court for production and for examination of witnesses.
So 110 is the production.
Yes, my lord.
2810 is the evidence.
Of PW number 2 and 4.
Okay.
Now, my lord, what I would like to stress here is that even after filing of this bail application, the respondent has sought time to submit their written objection for several times, if I must say. Now, today, the Learned Special PP had also praised that he may be allowed to argue on, orally argue the matter. So there is the case that this case has been pending for so long, even in the bail stage itself. And in the trial court itself, Due to long incarceration, the petitioner.
All right. So basically, Mr. Faghzwala, your sum and substance of your submission on this bail application is that there has been long incarceration.
Yes, my lord.
And there has been prolonged delay in leading the evidence.
My lord.
And there are 7 witnesses remaining, and there's no likelihood of the trial
Being
to
complete.
complete in a near future.
My lord.
So the vigors of 37 can be relaxed
Yes, my lord.
in some cases.
My lord. So, facts may differ in various cases, but this is a particular case where your lordship may consider the bail application that I have been incarcerated for more than a year now. I think it's 1 year and 5 months, if I'm not mistaken, that calculation. If I may be allowed at this stage to produce the proceedings of the learned trial court, which is not annexed in the bail application, my lord.
What is that?
I'll just place before you. To apprise your lordship that whether trial will be concluded soon, my lord. Now this case is registered in the year 2023, my lord. We have filed our,
There are some changes now.
there are some
You are
changes.
producing some orders which are somewhere at the beginning of the year.
Yes. Now, my lord, I have produced different orders, my lord. 27 to 24, 27 3 24, 25 4 24, 10 5 24, 15 5 24, and 29 5 2024. Now thereafter, my lord, as I have just informed your lordship, the next date is on 28/10/24 for examination of PW number 3 and 4. If your lordship will kindly see the lapse of time between 2 dates of examining the accused person and production of the accused person.
What are those dates?
PW number 1.
It's basically a monthly affair.
Your lordship will
Almost.
Your lordship will kindly see. Your lordship will kindly see. PW number 1 was examined on 27 March 2024. Has your lordship got it? In the
That's what-
deputation
See,
form.
Mr. Faghzwala, you didn't get what I said. It's a monthly affair. Every month it's happening only.
No, it's not a monthly affair. I beg to differ with your lordship. If
Then
your-
I'll tell you the dates. One date is 27/2/2024. Second date is 27/3/2024. Between these two, how much? 30 days, 1 month.
Yes.
Then next date is 25/4/2024. This is almost a month,
25
which is short of 2 days.
Oh, yes, on 25/4/2024, it was only for production, my lord.
No, production or evidence, I mean, the dates given here is basically, it appears to be on monthly basis. Except for this 25/4 and 10/5, slightly shorter time. And between 10/5 to 15/5, another gap of 10 days? No, 5 days.
And 15/5. Now,
15/5 to 29/5.
yes, and 29/5.
So it is not so bad as you project.
No, I'll come to that.
Then 29.5 to 12.6. What do you want to say basically?
Now, my lord, I will impress upon your lordship on that. Court may fix a short date for production, but that does not settle that it will conclude the trial very soon. Now, your lordship will see when the deposition of witness number 1 and witness number 3 was taken, the difference. PW number 1 deposition was taken on 27 March 2024. And PW number 3 deposition was taken on 21st August 2024.
Where's August? You're not giving me August.
No, it's in the deposition form, my lord.
In the deposition, okay.
It's in the deposition form.
Twenty-seven, 3. Twenty-seven, 3. So what is the reason behind? According to you?
There is one absconding accused, Parul. Maybe because of that, my lord. There was one accused in this case. There is one accused, Mr. Parul Hussein, who was
He's absconding.
Yes,
He was given bail.
he was on interim bail, but his anticipatory bail was rejected by this court. Now he is in custody.
Now he's in
He
custody.
is in custody.
Since when?
Just recently, my lord.
Okay. So that was the reason why perhaps there's some gap between the examination of the witnesses.
I cannot say, my lord.
Because insofar as PW1 is concerned, he was not cross-examined by the counsel for that person who absconded.
Yes,
PW3,
he was cross-examined by his counsel.
he was cross-examined. Anything else, Mr. Pagswal?
So, look, by the way, the trial has been conducted, my lord. It is very unlikely that I will get justice and I will. So, in the meantime, your lordship may allow me to go on bail based on the decision rendered by the Honorable Supreme Court. The yardstick may be different. In that case, Rabi Prakash case, I think it is 3.5 years. In other case, it's, I think, 2 years. In my case, it's 1 year and 5 months, approximately, madam. So I think I can take the advantage of that order if you. I beseech your lordship to consider this bail application on the grounds of long incarceration, madam. Your lordship has seen how the trial has been conducted. I'm not arguing on merits, my lord. Honorable Supreme Court has already said that Section 37 is not an absolute embargo, and it can also be dispensed with.
All right. That's all?
My lord.
May it please your lordship. Your lordship, now this bail application is an application on merit, your lordship, under 4337 of the Indian PS Act, your lordship. That Indian PS Act, my lord, actually, in terms of Section 37, my lord, has placed a very stringent condition, my lord, that normally cannot be done away with. And now, my learned friend had placed some citations from the apex saying that special consideration for dispensing with that section, my lord, may be done in his case. But my lord, that in the case which he referred and relied on, my the circumstances are very different. And within that 3 years that in that specific case, my lord, the trial has not begun. So that's the case. But in this case, my lord, trial has already begun. And regarding that, my lord, if I may take lordship to their own pleadings in the petition, lordship.
One question, Mr. Zoram Chana. Why witnesses are not being produced in a more
They produced, my lord, 2
closer
witnesses,
dates? March and August.
my lord. Up
So
to-
many gap in between.
Yes. It,
Any
even
difficulty in getting the witnesses? Who are the named witnesses?
witnesses, there are
They are from somewhere
seven
else.
remaining, my lord. Seven remaining. And my lord, I think
Who's conducting the trial?
the trial NDNPS special court, lord.
No, for the prosecution. Who's the prosecutor?
For the prosecution, Mrs. Larem Thangi, my lord.
There's a special prosecutor,
Special PP of NCB, my lord.
special PP.
My lord, before the trial. And my lord, my learned friend have themselves stated in their petition, saying that since one of the co-accused has absconded and that might be the reason why trial has been slacking, my lord. I think that might be correct. But now, when this honorable court, my lord, in terms of its order on 13/9 this month, my lord, rejected the anticipated bail application of Parul, my lord, the co-accused, who till that time was absconding. But now he is put in custody. So, regarding the long term incarceration, my lord, I think the case will proceed on speedily right now, my lord. Now, both the accused are now in custody, and trial will proceed on as best as possible. And that, my lord, I think would not be a bar.
See, where is the list of witnesses? Your charge sheet is in the form of a petition, but this is without any list? Oh, you have not made it, you have not enclosed it, Mr. Fagwala, because it's bulky.
I think it's there, my lord.
It's bulky, that's why.
It's in page 50, my lord. Page 50.
50.
50 and 51.
Okay, these are the ones. Number 1 gone,
Number 1 is examined, my lord.
then
Number 3 is also examined,
3
if I'm
gone.
not mistaken. And number 2 is the one left out, my lord. And number 4, they mostly are all within. So all except
4 is the
5
IO. 4 is the IO.
First IO.
Yes, first IO, 5
and
is
five
second
is
IO,
second IO.
then intelligence officer,
Yes,
something,
it is officer. Except the
seizure witnesses, reporting officer, forensic examination.
now
Yes, you've seen the decision. If such kind of delay happens,
yes, my lord.
you cannot say 37 is very stringent.
My lord. Considering the amount of this article, my lord, says in the present case, actually 1 year in custody is not a long incarceration, my lord. Actually, 2.5 kgs of heroin, my lord, is not a small number.
No,
As much as,
nobody's denying it's a small
my
amount.
lord, 250 grams.
But the
is
spirit
commercial.
applies, you see. The spirit applies, whether it be 3 years, 4 years, 1 year, or 2 years. It's the spirit behind,
Anyway,
the
now-
pace in which the things are proceeding.
Trial has already begun. 2 witnesses already examined, my lord. And now, since both the accused are already now in custody, and then the case will proceed on, even month to month. Even within 2 months, I think 2 witnesses can also be examined because they have to be produced every 14 days, my lord, before the trial.
That is for you to pray before the court.
That, my lord, regarding that,
How do we make an observation here that court will produce,
number 1, that is,
examine 2, 3
Now
witnesses
on-
at a time like that?
my lord,
You are the NCB. You should impress upon the court that
my lord, that will be done.
we need to speed up this trial. Person is guilty.
That will be done.
Definitely guilty, but we,
As far as
so that he does not have this kind of difficulties, this trial should be speeded up.
now, my lord, the strict limitations, my lord, put on the accused for bail, my lord, by Section 37 of the PS Act, my lord, stated that at 6 and 7, my lord, if I may read, Lord.
Yes.
As the provision itself provides that no person shall be granted bail unless the two conditions are satisfied. They are the satisfaction of the court that there are reasonable grounds for believing that the accused is not guilty and that he is not likely to commit any offense while on bail. Both the conditions have to be satisfied. If either of these two conditions is not satisfied, the bar operates and the accused cannot be released on bail. The expression used in Section 37(1)(b)(2) is reasonable grounds. The expression means something more than prima facie grounds. It connotes substantial probable cause for believing that the accused is not guilty of the offense charged, and this reasonable belief contemplated in turn points to existence of such facts and circumstances as are sufficient in themselves to justify recording of satisfaction that the accused is not guilty of the offense charged. And that in conjoint reading, my lord, with Section 54 of the NDNPS Act, the statutory provision, my lord. It says reasonable grounds and goes on to explain what it means by reasonable grounds. And now if I may take lordship to Section 54. For Roviendi and PSA.
Yes.
Presumption from possession of illicit articles. In trials under this act, it may be presumed, unless and until the contrary is proved, that the accused has committed an offense under this act in respect of, and there the list of drugs, the definition. That means, Your Lordship, presumption is drawn by the act. And unless the accused proved that he is innocent, he is presumed to be guilty. And as of now, at this stage, my lord, the accused cannot prove his non-involvement. So he is now presumed to be guilty. And that, my lord, in reading with Section 34, my, if I may take lordship to the same statutory provision, Section 35, presumption of culpable mental statement. In any prosecution for an offense under this act which requires a culpable mental state of the accused, the court shall presume existence of such mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state. So he has to disprove, my lord. He has to disprove the presumption that was laid down by Section 34. And in that respect, my lord, I'd like to rely on one citation from the apex court, which is 2015, lordship. 2015, volume 17, SEC 554, lordship. (2015) 17 SEC 554, paragraph number 12, lordship.
Yes, you were citing this 2015-17 SEC.
My lord. Now, the reason why I rely on this citation, Your Lordship, is that they themselves admitted physical possession of the seized article, and it is not an issue, my lord. They admitted that the same was also recovered from the vehicle which he was driving, and his only contention, my lord, is that conscious possession. Conscious possession. And for that, my lord, regarding this citation, if I may take lordship to para 12, my lord.
Yes, read.
12,
Read.
my lord. Testimony of Ram Singh, PW1. An evidence in record amply establishes physical possession of the contraband by the appellant. The appellant, being driver of the vehicle, by all probability must have been aware of the contents of the bags transported in the trolley attached to the truck. Once the physical possession of the contraband by the accused has been proved, Section 35 of the NDNPS Act comes into play, and the burden shifts on the appellant accused to prove that he was not in conscious possession of the contraband. So he has to prove that he was not in conscious possession.
Okay, anything else?
That, my lord, with that I rest my submission.
Your Lordship, may kindly allow me to place one judgment of this court.
Yes. On regarding?
Long incarceration. It is a case of commercial quantity in this case.
How long?
2 years.
2 years.
And in that case, it relied upon the Honorable Supreme Court judgment.
Which you had cited?
No, another case. Para 7, my lord. Here in this Nitish Adhikari versus State of West Bengal, if I may read, my lord.
Yes.
During the course of the hearing, we are informed that the petitioner has undergone custody for a period of 1 year and 7 months, as on 9/6/2022. The trial is at the preliminary stage as only one witness has been examined. The petitioner does not have any criminal antecedents.
In custody. Stop. He submits that out of the 9 prosecution witnesses cited, the prosecution has been able to examine only 2 of them, namely PW1 and PW3. Stop. Having regard to the pace at which the trial is progressing, it cannot be said that the trial will conclude in the next 2 years. Stop. Such being the position, he submits that the applicant should be released on bail, pending conclusion of the trial. Stop. In support of his submission, the learned counsel has produced some of the orders passed by the learned trial court, and also the following authorities. Column dash number 1. Rabi Prakash versus State of Odisha, 2023, live law, bracket SC 533. Number 2, Dheeraj Kumar Shukla versus State of UP, 2023, SCC online SC 918. And order dated 21/5/2024, passed by this court in bail application number 47 of 2024, bracket Lalompuya versus State of Mizoram and another. Next para. Per contract, Mr. C. Zoram Chana, learned special PP, submits that the case of the instant applicant is clearly distinguishable, having regard to the time he has been kept in custody, and that since a commercial quantity has been recovered, from his possession, comma, the vigors of Section 37 of the NDNPS Act will be attracted. Stop. He further submits that as per Section 35 of the NDNPS Act, there is always a presumption of culpable mental state of the accused person, and that the accused person is required to discharge the burden which is cast on him. Stop. Since the trial is in motion now,
With,
it
if I
cannot
may.
be said that there will be delay in the conclusion of the trial. Stop. He further submits that from the materials available on record, the applicant has conscious possession of the seized articles, and therefore, in view of Section 35 of the NDNPS Act, the presumption of the applicant the presumption that there are reasonable grounds to believe that the applicant is not guilty of the offense is not available. Stop. Under the circumstance, he submits that the application for bail should be rejected. In support of his submission, the learned counsel relies upon the case of Union of India versus Shiv Shankar Kesari, 2007, 7 SEC 798.
N. Baldev Singh, Lordship. 2015.
And Baldev Singh versus State of Haryana, 2015, 17 SEC 554. Stop. Next para. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. So stop. As can be noticed, the counsel for the applicant has stressed and argued that the applicant has been incarcerated for 513 days till date, and on that ground, he should be allowed to go on bail. To stop, the court has been sought to be impressed by production of the authorities such as Dheeraj Kumar Shukla, Supra, and Rabi Prakash, Supra. To stop. A perusal of the said decisions would go to show that the apex court was of the view that the vigors of Section 37 of the NDNPS Act cannot place an embargo upon the right of the person detained particularly when he has spent a considerable period of time in custody. .553 kilograms of heroin, kilograms of suspected heroin was seized from his possession. While he was driving an Ashoka Leyland truck bearing registration number AS11 TC, T for Tripura, TC 5863. Full stop. His vehicle was
DC, my lord. It has to be DC. The registration.
are you sure?
Yes, my lord.
Show me.
Your lordship will see at page 35B. It is the charge sheet,
No, Caesar,
my lord.
chart sheet can be wrong also.
Your lordship will see in the FIR, page 34A.
Why there is no Caesar memo regarding the truck?
It was seized, but it was released on Manama.
Maybe, but it should have been. It should have. If it was seized, it should have been reflected somewhere. Okay, make it DC, huh? Not T. D for Delhi. When it was intercepted at selling, stop. From the materials available on record, prima facie it appears that the applicant was in conscious possession of the seized article. Stop. Following the filing of the charge sheet, the trial has commenced, and as already submitted, 2 prosecution witnesses have been examined out of the 9 cited prosecution witnesses. Stop. Insofar as his long incarceration in custody is concerned, it may be seen that the same at this stage may not be comparable. Stop. Moreover, in the cited case, there was release of a co-accused person, which is not the case in the instant case. Further, in Dhiraj Kumar Supra, the observation of the apex court was that trial was yet to commence. Though charges have already been framed. Full stop. Such being the case, this court is of the considered view that the bail application cannot be accepted at this stage, and accordingly the same is rejected. Bail application starts disposed of.
Obliged.
Yes. You give him back this, no?
For admission, item number 1 and 2.
In this matter, respondent was supposed to file affidavit as per the order of this honorable passed on 23/8.
Who is supposed to file?
Respondent, my lord, government advocate.
Yes, where's the government advocate? Miss Caroline?
I'll have to apologize in this case, my lord. I have to seek some more time because the file was misplaced and I have contacted the department. They're sending me the information.
When?
They'll try to send it by next week, my lord. And I'll have
File was misplaced.
Yes, my lord. They have put up the file for approval. The last time I have talked to them. And it was misplaced. So instead of sending me the required information, it was still kept in the file.
So when will you file the,
My lord, let it come up after vacation.
give me a date.
May be taken up.
We'll fix it up on a date. Yes,
May be taken up on 8th of November, my lord. In the meantime, they may file their
8th November.
8th of November. Okay.
Okay, Miss Linda, I'll fumble on it. Additionally, AG submits that since the file was misplaced, the respondent authorities are going to send her the instructions shortly. And therefore, she prays for further time to file the affidavit, incorporating the instructions. Next para in view of above, and as no, before that, you write the said prayer is not objected to by the learned counsel. For the other side, in view of above, and as prayed for, list the matter again on
November.
8th November.
May I take before taking up item number 6 also, my lord? 6, my lord. Actually, I have to leave, lord. So I am, if not.
Sorry,
Item number 6 may be taken up now, also. If not convenient for.
you're in a hurry.
Yes, sir.
Call item 6.
In this matter also, they have to file affidavit.
Item number 6.
What is the matter?
My lord, this pertains to, my lord, not taking the actual the amount of my lord quantum of compensation, lordship. We are challenging the quantum of compensation, lordship. In this matter, my lord, notice was issued, my lord, and they have to file affidavit. My lord.
The petitioners have filed their additional affidavit on 23/8/2024. Have you given a copy?
Yes, already served.
And a copy of the same has been served to the respondents, according to the learned counsel for the petitioner. First up, the learned counsel appearing for the respondents submit that they may be given further time to file their counter affidavit. In view of above, and as paid for, further 4 weeks' time is granted
Maybe fixed on 8th of November along
to
with
obtain instructions and to file counter affidavit. List the matter again on 8th of November as paid for.
Right.
Item number 3.
Lordship.
If I may, Lordship. My Lord, Mr. Byung-Chu Goswami, who is an outstation lawyer, has requested me to pray for an adjournment on his behalf. That, my Lord, the respondent number 5 intends to change their counsel, so Mr. H. Bulbaya will be replaced by Mr. Goswami.
That is your headache. Why should the court wait like that every time?
My Lord, Mr. Goswami have to obtain NOC from Mr. Bulbaya and that to file his vakalat.
See, you don't have to recite all the procedures. We are aware of those things. But this has to be done at the earliest. If you see the previous orders, every time accommodation is being sought, court is not functioning at the whims of the respondent number 5. Mr. Ramzawa, we'll give them one more date.
Before
What we do?
vacation.
Before vacation, is it possible? I don't know.
My lord,
We have only 4 working days, and there'll be 1 day will be a division bench. Yes, what are you saying?
my lord, if possible, 22nd of October, because Mr. Goswami has a similar item with similar councils.
All right,
Admission here.
we'll fix it on that day with an observation that if you don't appear, we'll proceed.
Yes, my lord.
What's your good name?
Lomo Maralte.
Sorry?
Lomo Maralte.
Parties are represented by the respective councils, except for respondent number 5, for whom, no, respondent number 5, stop. Mr. Lomo Moralte, learned counsel, submits that the respondent number 5 will be engaging a new counsel to represent them, and since the formalities have not been finalized, he prays that the matter be listed again on 22nd of October 2024. Stop. It is seen that the case has been adjourned from time to time in view of the difficulties which have been cited today on behalf of respondent number 5. Stop. Upon considering the submission made, let the matter be listed on 22nd of October 2024 as paid for. It is, however, made clear that if no representation is forthcoming on behalf of respondent number 5, court will have no option but to proceed with the materials which are available on record.
Much obliged, Your Lordship.
Item number 4.
Yes.
Lordship, I'm appearing on behalf of respondent number 5. Lordship, we have just received Paraguay's comment, and we can file affidavit within a week. Lordship, if Lordship permit, matter may be listed after vacation.
You're Mr. Lalmun Siyama, is it?
Yes, my lord.
What about the affidavit from the others? CGC? You've already filed. Good. Then state? State also filed.
Yes, my
We'll await. Mr. R. Lomoma. R. Lalmun Siyama.
Yes, my lord.
Appearing for respondent number 5 submits that he has received the Paraguay's comments and he prays for 10 days time to file the counter affidavit of respondent number 5. Stop. It is seen that the other respondents have already filed their counter affidavit. In view of above, let the matter be listed again after the ensuing puja vacation.
Thanks.
No problem.
Item number 5.
Then one more line. In the meantime, respondent number 5 shall file the affidavit in opposition.
Lordship, this case, service is complete and they have filed affidavit, even though the state government not yet filing this case. However, in the similar matter, analogous case, Zoe Freulian and others, they have filed. So they can, it's ready for admission hearing.
Similar matter.
Similar matter in WPC 60 of 2023. They
There's an affidavit here
have,
by 1 and 2,
yeah, 1 and 2.
then
is the,
by 5 and 6 also.
yes, only the state government.
Your Lordship, we have got the vetted Paraguay's comments and we will file the affidavit in opposition by next week, Your Lordship.
Lordship, this may be taken up next week on 3rd.
What is the urgency?
The urgency is that, Your Lordship, the cess amount already deducted from the awarded amount is still lying in the before the Kala, not submitted to the MIDC also. That's what they have informed us, that since you have filed the case They have not disbursed to the MADC. And even though it's a covered case, Your Lordship, here we have our prayer is that they have deducted 10% cess from awarded amount, and they have not pay interest, and they have not yet appointed the presiding officer under section 53(2) of 2013 RFST LARR Act. So this is the prayer, three prayers you made here.
See, okay, insofar as the cess is concerned from the state, there's already settled thing.
Yes.
But I think the district council, they have
Yeah, they
their
have
own.
their own.
My lord, I'm for the MADC in this case.
They have their own law, and
So
on
how-
that basis they have deducted. But if you read their law, it's not mentioned that they have deducted. They are going to deduct it from the awarded amount, just for the land value.
Where's that?
Kindly see, Your Lordship, page 9, para 6.
Of the writ petition.
Yes, my repeat. Page 9, para 6. That the respondent authority under MADC had deducted 10% of the compensation award assessed by invoking section 23(2) of the Mara Autonomous District Council Act 2018, as well as the notification dated which was made in exercise of such and such, notifying that the MADC shall collect and levy revenue assessed to the extent of 10% from any landholder from the value of the land on any other ground with effect from 19/9/2019. Here the operative portion is 23(2), in exercise of the power vested to it by subsection 1 of this section and subject to the provision of section 22 of this act, the executive committee or concerned authority shall be competent by public notification or by official order to collect revenue from any land pass holder as it may deem fit and reasonable. B. To collect and levy cess to the extent of 15% or cost or charge, which may be increased or decreased and fixed by the executive committee from time to time by official order or notification from any landholders from the value of the land and on any other ground, and in the manner as may be prescribed from time to time for the conduct of spot verification, survey and measurement or any other administrative work or other ways as provided and envisaged under subsection 1 of section 22 of this act on certain and special occasion as the case may be, to collect such fees, costs, or charges for mutation from any land or pass holder, to exempt certain land pass holder from payment of revenue or other charges on sufficient reasonable ground. So it's here that the state government with the Revenue Act, they've made deduction 10% from awarded amount, compensation amount. But here they have mentioned that land value, from land value only, to collect such costs or charges from mutation and land value. So even though the state government Revenue Act is challenged in other cases, wherein it is observed that it cannot be applicable since the compensation is made under Central Act. So here in the present case also, the compensation is made under the LA Act 2013 Central Act. So it's the ratio can be applied.
So you are on the ratio.
Yes.
Otherwise, provision is there.
Yeah, otherwise
Now, whether it's 10% or 15%,
10% here.
you write 15 against section B, again there's 10% on top. Which one is the correct one?
10% here,
15 is to the extent of 15.
to the
Up to
extent of 15. So here they have deducted
Even
10%.
in paragraph 6, it says to the extent of 10%.
Yes.
Which one is the correct one?
The one which is in italic, that is reproduction of our provision.
Paragraph 6 says to the extent of 10%.
Yes.
Reproduction of 22, section 22, subsection 2 is 15%.
Yes.
How can the two things go together like that?
They have actually deducted from here.
No, no,
10%.
deduction is something else. What I'm asking you is
Yes.
whether it's 15 or it's 15.
15.
It says
or-
15.
Yes.
So from where do we get this 10%?
10% is the actual deduction.
Okay, the actual deduction. It can go up to the extent of 15%.
Yes.
Is that the position?
That is my understanding.
So they prefer to
Says 10%.
deduct only 10%.
Only
Yes.
10%.
But in that Mizoram case, it was 10%, is it?
10%.
Says,
Yeah.
which was interfered with?
Yes.
Or it was because of the amendment?
Because of it.
Because of the amendment,
Amendment.
number one, and number two is because in that particular provision in the rules, it was mentioned that acquisition undertaken by the state. Whereas in those cases, it was in relation to acquisition undertaken by the railways, which is a central authority.
Yes. Even the
That's why in that
2013
case, it was
act is a central act, Yalachi.
So you need to argue, I think.
Yes.
We cannot simply say it's covered case like that. You'll have to argue.
Yes, and the number two, with regard to the interest, this is a covered case. I have cited judgment also.
Okay, you see, they are ready with the Paravis comments. Let them file the affidavit.
Yes, they have filed in the other case, the same analogous case, that is, I have mentioned in the WPC 60 of 2023. Rolls-Royce, Diana and others.
60 of 2023.
Yes, Ilachi. Analogous case.
In this case, the state is yet to file the affidavit of opposition.
Yeah, we know that. What I mean to say is that analogous case, the same similar case.
There's one more case,
Yeah, one
WPC
more
60.
case, yeah.
And it says, it seems that according to the counsel for the petitioner, is that it'll cover this case also because they're similar. You examine that. We'll post it again.
On third,
Third may be difficult. We have a division bench on third, perhaps.
then first, 31st or first?
Ms. Dinari, is there some urgency in this matter? We can have it just after the vacation.
Because Lordship says already deducted is before the gala. So they were informed us that just dispose the case and we want to release.
They want to release.
Yes, because they still
Who's stopping them from releasing? Let them release.
without a court direction. They
When can you file your affidavit?
Your Lordship will be filed by Monday itself.
By Monday? Okay, so we'll make an attempt on first.
Your Lordship, within the first week of October.
No. First week, we have only 4 working days.
Just for filing.
You file it by Monday.
Monday or Tuesday, Your Lordship.
See, if they say it's similar with 60, in fact, you need not file at all also. You just examine that aspect.
yes, it's already filed.
Your Lordship will be filed on this day.
Instruction by the instruction by the opposite party private.
not the opposite party, madam. We're all the respondents. In fact,
But
Your Lordship, in this case, my
instruct
director-
her to file on Tuesday.
unfortunately, Your Lordship, in this case, rightly or wrongly, the notification is there. And they have not challenged that notification for deducting success.
But the
That has
thing
not
is
been
that
challenged.
it's not mentioned that they were deducted from the
And I've mentioned that in
compensation
my pleading
amount.
also.
So they can, it's not applicable in this case, you have said.
I think we'll need a thorough hearing in this matter, madam.
Before also you have heard so far. if I'm not mistaken, with my junior.
What about 60? It's still pending.
It's still
Yes,
pending, my lord.
When
still
is it going to be
pending.
listed?
I don't know the date fixed.
Please write. Ms. Louis, learned government advocate appearing for the state respondent, submits that she has received Paraguay's comments and she may be given a week's time to file the counter affidavit. Stop. Ms. Dinari T. Azul, learned counsel for the petitioners, on the other hand, submits that there's another writ petition, that is WPC number 60 of 2023, in which the state respondents have already filed their counter affidavit. Stop. Since the issue is similar, that will cover the case of the respondents, state respondents in the present case as well. Next para, considering the submissions made, let the matter be listed on 1st of October along with WPC number 60 of 2023. The state respondents to file their counter affidavit by then. Mr. Nalfa Pomal, learned counsel, appears for the respondent MADC.
5 and 6.
Bracket, respondent number 5 and 6. We'll see what can be done on that day. You try to file an affidavit and we'll have it with 60 also. Okay.